Welcome to our Convert to Green webinar, which deals today with the IP aspects and technology transfer aspects. So what do you need to do to transform your idea and your technology into a successful product in the market? And we have an expert for that today, Vassilios Albanis from Indicom Commercial Pathway, partner in the Convert to Green project. And Vassilios, I would say I'll let you introduce yourself quickly.
Sure.
For my introduction, I will do it with a quick presentation. So now it's your turn.
Thank you, John. Very quick, and then we'll jump back into John's presentation. My name is Vassilios Albanis. I am a technology transfer, IP strategy and commercialization expert. I work for a company out of Ireland called Indicom Commercial Pathways, and we are a partner in Convert to Green and other EU projects. Focus of my work tends to be IP strategy, collaborative IP, licensing frameworks, and tech transfer activities. I'll hand you back to John, and then we'll talk a bit more about who I am, what I do when I start my side of the presentation.
Okay, perfect. Thank you very much for the quick introduction. Before we go to your side of the presentation, I think most of us know us here, but some might not. So I will give a quick introduction to Cat Market as the organizer of the event and to Convert to Green as the EU project that pays for it. So that's the Convert to Green project is here the frame and giving the frame for the webinar, and I will tell you and explain you in a moment why and how this belongs together. A short introduction to Cat Market. So we are a company that support technology transfer, actually on a holistic view. So we are here for simplifying and accelerating the collaboration between the R&D providers, between those that own research results, between the companies that want to commercialize the results and that want to introduce a new technology into the market, and between those that are very important that give the money. And we understand ourselves at first as a matchmaker, bringing people together, and second as a translator, translating the language of the companies to the language of the scientists and vice versa, and to the language of the funding authorities. And a third part, we are also, let's say, some kind of consultant, basically telling the next steps, helping who is the right person and helping what to do next. And we have two products. Basically, one core product is our digital innovation marketplace, which basically means that we know who is doing what in terms of innovation in Europe. So Vassilios has an offer in our platform filed. So when you need a patent attorney, when you need someone who is expert in exploitation, then basically you find them on our platform and you will find Vassilios, but you will also find other guys. And if you need mechanical testing, for example, or a fire resistance testing or something like that for your technology, that's something you find also on our platform. Or, for example, for the people here in the room, if you need a coating machine for atomic layer deposition to make a gas barrier coating or to make dielectric coating, this is also, for example, the company SRLD, and you will find them on our platform. And you will find them together with funding opportunities and together with relevant knowledge, so you can immediately build a consortium on our platform, build a project, and find the funding opportunity and make an EU project, for example. And that's the second part of our business. The second part of our business is that we use the data in our platform to connect people and to build R&D and innovation projects. And we plan the projects, we coordinate the projects, we know all the steps needed from the idea to the product, and we involve the right experts to make this project and this innovation a success. The platform itself, just a few numbers. Some people really like numbers, and same as me. And we are on more than 1,000 offers in the platform at the moment. More than 1,400 funding opportunities, by the way, including the Horizon Europe EU calls for next year already, for 2026 and 2027. So who is looking into long-term preparation of a consortium and a proposal, you will find them on our platform. And the next also, we have a lot of technology market reports, more than 1,500 documents at the moment that, for example, include information. I don't know what's happening here. The slide is always moving automatically. Also include information on future regulation, like strategy reports from the European Joint Research Center, like results from the Horizon results platform from EU projects, but also scientific reports from national funded projects. And we are, one of our big strengths is really the R&D project preparation. We have the Convert to Green project, where we basically did the planning of the project, brought together the consortium, prepared the exploitation and the go-to-market strategy in the project, of course, together with the experts, and where we, while the project is running, support the technology transfer of results that are coming up in the project. When we do a Horizon Europe proposal with 60% success rate, together with our partner Amiras, Martina Chopard here in the room, if you want to know more. And finally, we also have, after the project, with what is the next step, get money for the commercialization and basically let us help to bring you the results to the market. And yes, we will share the slides later on. There are both the slides for the main presentation and these introduction slides. Yeah, and the meeting today is organized by Convert to Green. And why is it Convert to Green? Convert to Green is an open innovation network or open innovation testbed in the official language of the European Commission. What does it mean? We are a network of R&D organizations, business consultants, IP consultants, technology consultants, and of course, research infrastructures that came together to support small and medium enterprises in bringing low carbon circular materials to their product, to their market, and to their application. So basically, there are also some of these small and medium enterprises here today in the room. Came to us, these companies come to us like Karlsbad and ask, we have an invention, we have a new product, we have, for example, a low carbon cement. It's a very nice, eco-friendly construction product. Can you help us to do, for example, a life cycle assessment? Can you help us to scale the process up to market? Can you help us to connect us to the customers and to the right application partners? And that's exactly what Convert to Green is about. As an innovation network, we have the technical, the IP, and the business expertise to really help you with, or help companies with bringing their ideas to life. And we do this in multiple business fields as we are focusing on circularity. We are very broad in the application ranges. We look into smart textiles, where we have a rapid prototyping capability with the TETV in Greiz. We are looking into processing and recycling of plastics. We're looking into nanomaterials, pellets, fibers, especially in the bio-based application, flexible electronics, and have all the services needed to validate that your solution, your idea is really eco-friendly. And there's the toxicity, ecotoxicity, human toxicity analysis. It's critical raw material recovery and recycling. There is the life cycle analysis, the techno-economic analysis, and the social impact analysis. That's something that is urgent and it's getting more and more important these days. And finally, and that's here, not intentional, but although it's here really on the last thing mentioned, but which is for the business development, I would say almost the most important is the IP business and technology transfer planning. And with that, I would like to close the introduction. Just before getting to you, Vassilios, there will be some webinars on, so if you've got interest in using the CAD Market platform, there will be the next two webinars will really be dealing with our CAD Market platform. And we are rather international, but also local. And that is sometimes a challenge because if you're local, you need to speak the local language. So the next webinar will be for Germans, in German language. But you also want to be international, so you need to speak the internationally accepted language. So the webinar after it will be in English. So you don't need to join both. If you are interested, it's just the one that matches your language needs. Finally, Vassilios, it's your turn.
All right.
I'm done.
Thank you.
Any questions up to now? that's not the case, then I would say, Vassilios, let's go.
All right,
There we are now.
I'll share my slides. I'll share my window, and hopefully everyone is able to see this. I'm using two monitors, so if you see me looking away, it means I'm looking at on my laptop and then the screen up there. Well, hello again from my side. Thank you so much to John for actually enabling me to make this presentation today. We've had a discussion with him, and I'll explain how this came about. The discussion today is what I'd like to sort of call to explain it as introduction to intellectual property, or IP, collaborative projects, and commercialization. Now, the idea is to go through some intellectual property fundamentals, discuss how intellectual property fits into the context of a collaborative project, for example, Convert to Green, its open calls, and other similar EU-funded projects. We'll go briefly over some considerations around the licensing frameworks and framework that enables exploitation or use of intellectual property. And then we'll go briefly again through a commercialization process that can move results from concept to the market. Like we said, the session will be recorded, and we're going to share the slides and the recording later. I think you can use the chat if you need any comments or any questions, and I'll ask John to monitor that. And in theory, it will be about 60 minutes, or we'll see how it goes. Again, my name is Vassilios Albanis from Inlicon Commercial Pathways. As I mentioned, IP strategy, technology transfer, commercialization. And what you'll get from me today is a practical view on IP, collaborative projects, and the commercialization process. And this practical view comes from experience, specifically from Convert to Green, other EU-funded projects, and broadly speaking, from technology transfer experience, spin-outs, and so on. In terms of agenda, it's the discussion, the presentation is split into three parts: intellectual property, IP and exploitation, collaborative projects, and then the commercialization structure and the process. And we'll have some takeaways and some key learnings, next steps, and hopefully some time for Q&As at the end. I did add a slide about Convert to Green. John explained it. So I'm not going to go through it, but Convert to Green is one of the main OITBs, Open Innovation Test Beds, fairly successful and very with a very sort of a powerful network of specialized facilities. And I, certainly invite you to look into the facilities and the facilities and the opportunities afforded. Couple of notes. A couple of thoughts why this discussion matters and why we're doing this. So again, broadly speaking, I think everyone in this call and broadly will agree that innovation is important. It's a really important tool, and it's effectively identifying and coming up with a new way of doing things. This can be methods, can be product, can be process, and so on. It's an open sort of ended concept. My experience is, and again, from a practical perspective, that you can consider intellectual property rights as an emergent property of innovation. And that is, innovation itself is all about knowledge, all about know-how, and all about moving these from place to place. And that implies a degree of ownership, it implies a degree of having rights over that ownership, hence the concept of IP rights. And on top of that, we have the concept of exploitation, which we'll touch briefly, or we'll touch a bit later down the line. And in short, exploitation is the framework by which you take the rights, the IP rights, the knowledge, and the know-how, and leverage those to produce an outcome. And that outcome can be commercial or otherwise. Again, as I'm sure you all know, it is challenging to take an idea to the market. It's just challenging to translate an innovation into a product, into a process, introduce it into a project and so on. And there are lots of layers and levels of complex and complicated sort of engagement within, between the stakeholders, within EU projects, between the partners themselves, or between partners, researchers and SMEs, particularly through the open calls. And I think that's how we came to this discussion. So John and I have looked at a number of sort of open call, I've been on a number of open call discussions through Convert to Green and through other projects. So one of the things that sort of jumped out to us was the importance of understanding making sure that all stakeholders understand how IP works in a collaborative context and how you can then set up mechanisms, establish these mechanisms to manage the IP-driven activities, and hence why we're having this this discussion today. One final sort of a quick note before we begin: the content and the discussion are presented, and the subject matter in the discussion, in the presentation, are presented in a broad manner. As I'm sure you'll agree, the underlying concepts are very complex and would need deep attention. I mean, in fact, you can spend a whole day's worth of a webinar just going through various intellectual property elements and or licensing negotiations and how to structure a licensing and so on. So today, let's consider this, I view this as an introduction into the space where IP, collaborative work and commercialization coexist. And the content, I feel that is applicable to researchers, whether you are at an academic institution, a research organization, an innovator within an SME or an SME itself, and you may be a partner on an EU project or looking to become a partner on an EU project. So, and because of this sort of complexity, the overall complexity, I think the intention is to follow up with a set of webinars and discussions where we're going to focus on particular aspects of the overall landscape. So today, consider this as looking at the big picture, and then following that, we're going to dive deeper into specific areas over the next few months, I think. So let's move on. Let's start with part one, intellectual property. I think the natural first question is intellectual property. By the way, sidestepping here, I assume that the majority of the people have some understanding or have some exposure, or have had some exposure to intellectual property. So like I said, I'm treating the subject in a broad manner without entering into deeply into any legal aspects of it, but enough to allow us to cover the key points that I wanted to make. So just so we're all on the same sort of a page again, the definition is as presented by the World Intellectual Property Organization, WIPO. Effectively refers to creations of the mind, and I highlighted that. I'll make a comment on that in a moment. These might be inventions, maybe artistic works, design, symbols, names, and etc., etc. More specifically, intellectual property includes any creations of the mind that can be legally recognized. And the way that it's positioned like this is, now that we live in the age of ChatGPT and AI and the impending AI apocalypse, intellectual property remains firmly in the realm of the human mind. So that's why you cannot have an AI recognized as an inventor yet. Well, that will probably come about in the next 5-10 years. Coming back to the discussion, so any creation that can be legally recognized and protected, and effectively gives exclusive rights to the creator or the owner. So you come up with an innovation, you claim it as yours, but so the framework, the international intellectual property network then gives you the access, but it also asks you to disclose that. However, that gives you the right to benefit commercially or control the use of your intellectual property assets or intangible assets. Strictly speaking, IP offers a broad protection. And I'm sure you already own or in the process of creating valuable intellectual property through a software script, a novel method, a brand or a logo or a prototype and so on. So keep that in mind that there's always intellectual property inherently and intrinsically present in your work and in your creations. This is the first of many tables on this presentation. And I tried sort of to capture a broad idea of IP types on the left-hand side and effectively what's protected, some examples, and what administratively how it works. I have highlighted the IP types that tend to be the ones that we most work with: patents, trademarks, copyrights, and trade secrets. Obviously, again, this is just a subset of the broader IP rights ecosystem. And what I wanted to sort of briefly show is that each IP type has a particular function, has particular use. For example, if you look at patent, it's all about something that's new, that's non-obvious, and has a technical effect. So you to patent something, it needs to have a technical effect. So you're looking at, for example, devices, hardware, and so on, algorithm with technical effect, software. Some of the IP types you have to register. Some are registered or some are unregistered. So, for example, patent is a registered IP right because you have to go through the process of submitting or filing your application. It goes to the examination office. It gets examined. The examiner comes back with all sorts of comments, etc., etc. And then there's a process of to and fro and prosecuting your idea with the examiner. If it's successful, you get 20 years of duration in the lifetime of a patent. And you typically use that when you have a core technical advantage or an advance in a technical development or a development that has a clear technical effect. And you want to have exclusivity and own it and control it. Trademark is also used extensively. I'm sure you also use it yourselves in your line of business. And it's all about identifying your brand. And it is still a registered intellectual property type. You still have to go through the process of registering it. And it lasts less than a patent, 10 years. And it's all about ensuring that your brand gets the recognition, you protect your supply chain and your value chain and so on. Copyright arises from anything that you produce. For example, this intellectual property presentation has an implicit copyright because it's something that I put together, and the shape, form, and function of it can be strictly speaking, protected under copyright. It lasts the lifetime of the author me, plus 70 years, which is a long time for a presentation. And effectively, it works best when you have content, documentation, when you hand out sort of leaflets and brochures, etc., etc. And software falls under copyright, and you get default copyright protection on software, which you can then patent if you want, if there is a technical effect. That's a subject of a different discussion. Finally, trade secret is effectively when you don't want to disclose something, but it's still very important, very critical to a process, like a formula, a source code, a data set, and so on. Then you don't release it, you keep it hidden, and that becomes a trade secret. It's indefinite as long as no one discloses it. And you usually use it when you want to stop someone from sort of reverse engineering your source code, your particular kind of a black box, but you have to keep it secret at all times. Now, leaving aside the sort of the whole kind of ecosystem of IP assets, of IP, you have to look at intellectual property as an asset for your company, as a strategic asset. Just like you have tangible assets, intellectual property is an intangible asset. And it gives you, like with any asset, it gives you certain benefits and advantages and challenges, as we'll see later. So it clearly gives you control because you decide how others can use your innovation. You can choose whether you want to release it out in the open, excuse me, as an open source. You can license it, you can set up a spin-out, you can create a joint venture with a collaborator, or you can choose exclusivity and no one else uses it apart from yourself. And therefore that generates value which you can then capture, because if you allow it, if you give it to someone to use it, they have to compensate for you or at least credit you. And this is the key point of commercialization. Without this, you cannot commercialize. Otherwise, this transaction wouldn't work. It gives you the opportunity, provided you're different, you sort of differentiate from the rest of the market, to either enter into a new market or create enter into a market or create a new market. And this is usually where the idea of a patent portfolio, when you set up a set of sort of patents or IP portfolio around you, you can use it to block your competitors and then push into new segments. If you're an SME, if you're a spin-out, if you are a TTO and you're looking at investment, then I'm sure you'll know that investors require some evidence of that intellectual property portfolio embedded within your idea. And even better, they want some reassurance that you can protect it. Otherwise, it won't be able, they won't be able to invest and they won't be able to scale it properly. In many cases, as we'll see sort of as an example, we'll see a bit later down the line, having intellectual property into a discussion, bringing that into a discussion is it can help you with your negotiation. Whether you're an SME, discussing your intellectual property with a bigger organization, a university with SMEs, or as we have experienced, part of an open call discussion. Intellectual property, the main premise, the key premise is that it's an asset, can be traded, can be licensed, can be sold, can be used in any way possible, within reason, obviously, in any business negotiation. And additionally, from the perspective of the environment that most of us occupy, intellectual property is a very strong collaborative tool and lever, because it can introduced into a number of projects, and it can be then used to generate intellectual property and enable additional collaborations. It sort of follows through from there. So as an asset, you can develop it and deploy it and implement it in a defensive or offensive or a collaborative manner or reputationally, and it fits your particular circumstances. If you're a partner in an EU project, if you're an SME innovating, if you want to go into the market, if you're a university tech transfer office or a spin-out or an innovator and entrepreneur, there's always you can leverage your ideas in a way to give you that immediate benefit. But it's not all easy. Like I said, IP is a great tool. It can give you a lot of benefits and value, but it has a lot of challenges that we have experienced as IP professionals, as stakeholders and partners in EU projects, and as SMEs and spin-outs and so on. It only adds value when it's managed properly. For example, it's easy to file a patent, but if you don't have a follow-up plan for it, as we'll see later on, it's not giving you anything. And another key consideration is a comment to make is that every protection route has trade-offs. So if you remember the table I showed a few slides back, had a lot of sort of potential types of IP and how you can leverage them, and so how you can protect them, what protection means for each one, and so on. And it very much depends on the circumstances, and there's always a balance to be made between various considerations. Whether you want to have a broad scope, you want to protect as much as you can, but versus speed. Whether you want to keep something secret or disclose it, but through protecting it, and then cost versus coverage. Whether you're going to protect it across a large area or or a narrow area. And from experience, especially in EU projects, and especially when it comes to IP from EU in EU projects and projects in general, most issues arise at the point of use. As soon as you put intellectual property, as soon as you put intellectual property at the point where it gets deployed, implemented, used, and so on, that's where the problems typically, that's where the challenges arise. And more specifically, if you're in a collaborative project, a joint research project, and there's an imminent publication, that immediately changes the tone of the discussion. You know, can we disclose before protecting? Is there something to protect? How can we achieve both? Which are not mutually exclusive, by the way. If you're in a collaboration, the discussion becomes, and we'll see later, who owns it? What sort of rights do we get, or do partners get over arising IP, over background IP, over results, etc., etc. If you're raising funding, again, can you put that intellectual property into your investment package? You know, are there any third-party rights and so on? So that's where most of the discussions arise and most of the challenges. Therefore, all the activities and actions are very critical in terms of time and when to do it. So, you know, you have to control disclosure. You have to have priority dates of when you can do something. You have to, if you introduce, you know, if you're in a collaborative project, you need to be able to introduce IP in a project in a specific way that does not sort of impede you from using it otherwise, and so on. And to achieve all this, you need governance, you need compliance, which again implies clear terms of engagement, like ownership, like assignments, or who came up, who is the inventor, or do they have the right to invent, and so on. And any sort of data and code hygiene in the background. For me, the most important challenge and also lesson is that, hard lesson, is that intellectual property must complement, one could say serve, the exploitation plan. And that can be anything. It can be your project plan, it can be a business plan, it can be the intention to spin out, and so on. Otherwise, it becomes shelfware. You know, it's sort of, you know, you pay for something, you don't get a return. It just sits on the shelf and loses its value. So that's, if there is one of the things that I want you to take away is this: you have to have an exploitation plan for your IP to work. Otherwise, intellectual property doesn't do anything. It's just a legal title with no practical value. And again, trying to break down what common IP challenges are, again, from experience, from what we've seen in projects, from what we've seen in working with SMEs, what I've seen working with spin-outs and TTOs and so on. There is a common sort of a set of common threads, and I've sort of highlighted again the ones that tend to be the most typical. Top amongst those is the disclosure before filing, so protecting, before deciding what to do with your IP. And that effectively is, it's bad news for any kind of intellectual property, because you want to be able to deploy it, you want to be able to disclose it in a way that you control. As soon as it's out in the open, then it becomes public, goes in the public domain, and anyone can use it, which is really bad for novelty, and effectively, in some cases, at best limits what you can patent, what you can protect. At worst, just completely destroys any opportunities to protect a patent. So you lose that value. So what I've always did with, you know, working with sort of partners and stakeholders in projects, in universities and so on, is you put a very clear do not publish. You always put these sort of clear embargoes and safety interlocks. You don't allow any of that IP to be disclosed. And that disclosure can be inadvertent by, you know, having the presentation slide open when someone walks in, or you present it at a conference without realizing, without actually having evaluated if there is intellectual property, if there's novelty, and so on. Again, sidestepping, I've had cases where we had to take presentation slides down, posters down from a conference, because they disclosed or they mentioned something that could be considered as disclosure. And you can imagine the academic team were not happy about it. Coming back to the comment I made earlier about the value and the necessity of the connection between the exploitation plan and the IP. If, or the challenge arising, common challenge is when there is no alignment between the IP and the exploitation plan. And then you have effectively, you have cost without value. You pay money for nothing, file a patent without value. So you always have to ensure, the solution is that you always have to ensure that there is alignment between your revenue model. And that revenue model can be anything. It can be a university TTO needing to have revenue, to get revenue arising through licensing agreements, an SME through sales, through licensing, through entering into sort of a joint venture projects, discussions, and so on. Maybe simple impact. You may not be interested in actually making money out of it, but you still want to generate impact. Therefore, you have to, again, to have that as an exploitation intention and plan. Another key issue that we've experienced and I've seen in various circumstances is errors, for the lack of a better word, mistakes when it comes to ownership and inventorship. Just like in an academic paper, you cannot be included unless you've had, at least in theory, you've had your ideas included in that paper, or your help with getting the work together and so on. The same with intellectual property at all levels, especially at the patent level. You cannot make a mistake in terms of who came up with the idea and who is included in that. And again, all those sort of legal concepts around IP and ownership and so on will be dealt separately in a different webinar. I think for the scope of today's discussion, I'm going sort of over the majority of the legal elements and sort of focusing on some practical issues and challenges. So coming back to this, to avoid any disputes whereby 3 months down the line, someone comes up and says, wait a minute, I was involved in that work. I came up with a few ideas, but my name is not on it. That immediately makes your patent and any right unenforceable, because you can go, that individual can go back to the authorities and say, not included, inventorship and ownership are not correct, and therefore if it's the EPO, for example, the European Patent Office, then they will pull the patent, and then that can be disaster from many different options. So you have to clearly define what your background is, what the knowledge you brought in, the foreground, and so on, and then record everything. Make everything sign their letters of assignments. Finally, another main issue that I've seen in a lot of projects is there is no provision for follow-on budget in terms of maintaining a patent, especially a patent. When you file a patent, APO, for example, and so on, there is a cost. There's a cost at the point of doing the filing. So you have to pay your patent lawyer to sort of draft the specification, the patent, then file it, etc., etc. So all that costs money. Most of partners that we've had this discussion with always sort of stop there. However, we have to tell them that beyond that, there are still a long prosecution cycle to take place, where you constantly have to negotiate and discuss with the patent examiner, and in as much as sort of convincing them why your patent should be filed and should be granted and so on. And all that costs money, because you have to pay your patent lawyer to do that. You have to pay annual maintenance fees and so on. So if you don't pay, your patent falls. It lapses. You lose the patent. You don't have anything. You don't have it. You don't have the rights over it in any case. So it goes back in the public domain, and therefore you lose all that effort. What I typically suggest is that when you do file a patent, you put a 3 to 5 year sort of a forecast for what kind of funds you'll need, how much you'll need to pay, costs, and so on. It sounds very simple and very obvious, but you you cannot imagine how many times we've had this discussion with partners and inventors and researchers who, very much believed that by filing the patent, that sort of just brings the end to it and everything is fine. So why I sort of went through this kind of a complicated discussion. I wanted to demonstrate that IP part, IP, intellectual property, broadly speaking again, is part of your innovation journey. And innovation journey can be anything and can be very specific to your circumstances. If you're a researcher at a university, at a research organization, your innovation journey is effectively when you sort of conceive the idea, you do the research, you sort of develop it, you technically develop it, you do your prototype, etc., etc. If you are an SME, you pretty much follow a similar sort of a trajectory. You come up with an idea internally, or you bring an idea from the outside, you develop it, you fit it into your patent portfolio, your product portfolio, you see how it goes in the market, and so on. So we'll go through those sort of those trajectories in a moment. But what I want to say is that, very importantly, everything, all the decisions you make, and all the actions and activities you undertake, typically arise from that innovation journey. So they're not separate from it, they're driven by it. And that makes it, I think, obvious that there is no one size fits all. You cannot just, take a cookie cutter and sort of make the same process. If you like, they make the same decisions, as you say, no process, the same decisions fit across everyone and all the stakeholders and so on. And the practical, if you like, from experience here, is that you have to plan in advance. So your technical development effectively fits into your exploitation plan, fits in your innovation journey and so on. So when you get a new idea, you know what to do with it, how it goes, how you protect it, and so on. And another table, we haven't had one for the last 5 minutes now. And on the left-hand side, like I was saying, most innovation journeys effectively have a common pathway or a common trajectory. You start from a discovery or ideation and discovery, you go through some sort of a proof of concept, you then prototype your idea, your proof of concept, and you validate the key sort of assumptions. You then move on to pilot it and sort of pre-launch it, depending on what it is you launch, and then you sort of expand. Obviously, a side note here is, although the stages are the same, the depth and complexity of activities and objectives and so on very much depend on the subject of your innovation. I come from a hardware background, so our proof of concept and prototype and validation cycle was much longer. We had to sort of have a whole optical table with the lasers and sort of the optical fibers, and et cetera, et cetera. So it took much longer to fulfill that cycle from someone working on a software-based solution. But the intentions are the same. The objectives are pretty much the same. You at the ideation, your main point is to kind of to consider what other intellectual property exists are there. You do a search and you start looking at, are there sort of similar things? Should we be worried? Should we be looking to protect and so on? Do we need to keep the work confidential? And very important, you manage it through good laboratory practices, wherever you are, good note-taking practices. You have to keep an inventory of things. You have to sort of keep your lab book or notebooks. In some cases, we have to sign sort of each page of the notebook to make sure that, it was clear who did what. So without wanting to go through that in any sort of extensive detail, your idea, your innovation stage and your trajectory are pretty much similar across different disciplines and research areas and industries and so on. However, the key IP actions are the same. You always look to identify intellectual property. You want to keep things confidential. You want to make sure that you have good note-taking and data management practices, and so on. So as this will be available to you later, you can sort of go through it and see how and where you fit. So for the moment, for the time being, let's just move on. Like I said, I'm not going to go through the deep kind of legal aspects of protecting intellectual property, and I'll say why I sort of took patents as an example. This will be the subject of a different webinar. It's much more sort of involved and much more complicated and so on. However, typically in collaborative projects, EU projects and research, the main sort of a driver or the main sort of IP asset is a patent. And there are 3 ways you can protect the patent across Europe. Again, I'm looking at this from a European perspective. You can either file it, protect it at a national level. You know, you're in Spain, you file in Spain. You're in Belgium, you protect in Belgium. Or you can go up to the European Patent Office, which sort of allows you to choose protection across Europe. And then there's the unitary patent and so on. Or you go to the PCT, which is the Patent Cooperation Treaty, and that's sort of an international intellectual property pathway. Typically, the latter is what we used to do at a TTO, where we wanted to enable a long time to between when the patent was sort of fully examined and so on. So here, sort of, you spend 33 months before you start getting those reactions back from the national examiners. And that gives you a long runway if you're an academic sort of a research group or spin out to refine your idea, get more investment, get proof of concept funding and so on. If you're an SME and you require specific protection of a particular idea at a particular location in Europe, then you usually go for a national route. It's faster, it's lower complexity, and then it allows you to enforce your rights quickly. So if you want to manufacture something in Germany and you want to protect it in Germany, then you go to the German patent office and you file a patent there, which gets granted typically faster than going through the EPO. And then you're protected in Germany. And after that, you can choose whether you want to move on to other areas. So all this acts as a segue to saying that IP is not just about protecting. It's not about just the legal action of registering your rights and say, I am the inventor of XYZ idea and so on. It's all about taking into account the positioning of your IP, where you place it, the timing, when you do it, and for how long, and ultimately how and whether it can actually capture value. So, so to extract that value from your innovations and from your IP needs strategy. You need a strategy, just like any other sort of activity, commercial, academic, and so on. You need a strategy. In this case, an intellectual property strategy, which needs to be tailored to your circumstances, and importantly, it has to be aligned with your exploitation plan. Again, I cannot emphasize this enough. Your exploitation plan is the key starting point, because it tells you where you want to go, what you want to do there, why you want to do there, how you're going to make money, etc., etc. And IP comes in as a block into that exploitation plan. So you have to tailor your strategy to fit your circumstances and intentions. These may be different for different people. If you are a partner in an EU project, then a collaborative project, broadly speaking, then you have to look at what are the exploitation intentions, what are the post-project intentions of your research project. If you're an SME looking to license your idea or sell it, then again, your IP strategy needs to reflect that, and so on. If you're a TTO and you want to spin out, again, very specific circumstances and trajectories. So it's And the strategy is effectively a proactive plan. Again, that needs to be stressed. It's not something that you write and you sort of just leave it in the background and you react to circumstances, meaning you don't react to novelty. You don't suddenly, if you're an organization or a university, you don't sort of suddenly spring into action because one of your researchers, one of your staff came to you and said, I've got a great idea. I think it's sort of valuable, we can protect it. You approach them actively, proactively, and you say, okay, let's sort of see what you're doing, how's your research going, where are we headed, and so on. We want to establish a market into that territory, etc., etc. So how can we enable that? So you're looking to make decisions with your strategy that sort of effectively are how to identify it, what to protect and why, when to protect it, what kind of protection, who owns it, especially if you are in a collaboration, where to go geographically, and how's that IP going to be used and add value to your company, your organization, or your spin out, or yourself if you're an independent entrepreneur. But that has to be constantly reviewed and aligned and always built around the exploitation plan, not the other way around. Again, the exploitation plan is the starting point. IP strategy is a block that enables it. It's a function, it's an underpinning activity. So if you are a startup, like I said, looking to raise investment, then you probably need a broad early protection through patents. If you want to license it, then you need to have a strong analysis to understand whether you can use it, how you can use it, and so on. So the typical mistake from experience, from what I've seen, is that you develop IP first and then you decide what to do it. By that point, it's too late because you've already lost that. You have to spend a lot of cycles going through the why and how and where and et cetera, et cetera, et cetera. If you have all those things in place, then you can immediately, as soon as IP is developed, you can immediately place it at the right place and at the right position. So again, integration with exploitation strategy is essential, how you exploit it and so on. If you are in a grant-funded project, then typically IP and exploitation strategy are often required to be in there up front. Depends on the project, but that's sort of our experience. Again, the left-hand side here on the table shows you the key elements of an IP strategy, highlighted, what are the key objectives, what you should be looking at, the protection and the portfolio, clearly ownership and inventorship, and where you're going to go, where you're going to exploit it. Again, take this table, look at it, and then look at this against and sort of compare it against what you're doing and how you manage things to see where you can find the alignment and what sort of else you can add to your strategy. So coming out of the end of the intellectual property, if there's one thing that I wanted to emphasize again, is that IP is a strategic asset for your company, for your organization, for you as a researcher. And therefore you have to build an IP strategy that supports and serves your exploitation plan. That is as simple as that. I think we can leave it there. So moving on, and out of breath, IP and exploitation collaborative projects. Let's first of all define what exploitation is, because a lot of people, when you ask someone, you get a different answer. We usually go back to what the Commission says, what the EU say. Exploitation effectively is, if you develop something, results, etc., 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 is how you use that, how you make use of that. And that you can use that in a commercial, in a societal, political sort of or aimed at improving public knowledge and so on. My, if you like, focus and my sort of a particular interest is a subset of that is when you commercialize your results. And that is you take your results and you commercialize it, trying to gain a commercial benefit and value. And here's where the confusion is. Many project teams, many SMEs, many researchers tend to confuse protecting IP with using it. Like I was saying earlier, there's no provision for sort of a long-term thinking, or there's lack of that long-term thinking. So if you talk about a patent, if you file a patent, immediately that sort of becomes an end to itself. but you're not using it. You're not sort of putting any art on any thought on how you're going to take that. So that's where the exploitation strategy focuses on, where the IP will use, who will exploit it, and what sort of revenue models will enable by it. So typically, as we're talking about collaborative projects, and this may be EU collaborative projects, maybe joint research projects, and so on. There's a number of sort of things that you want to pay attention, and that is the ownership, who owns intellectual property, who can use it, what roles each partner has in the development and exploitation, what are the exploitation routes. Importantly, revenue sharing, again, IP is an asset, commercially transacted, and so on. And make sure that you keep an eye on the disclosures. So from experience in EU projects, Horizon Europe more specifically, this is where we've seen the majority of the issues arising. And then, like I said, ownership and access, background, and arising results. Joint results, what happens when you have joint ownership? That typically complicates licensing and enforcement. And that's where usually we have to step in and sort of set up licensing rules to enable partners to deploy, implement, and exploit results based on their particular circumstances. You carve out areas based on field, on territory. You grant cross licensing agreements, and so on. Publication versus patenting, again, big issue with in projects. Strong drive to disseminate, as exploitation is part of the bigger dissemination and communication activities and initiative. So there's always that sort of a conflict between protecting and disseminating, and that's again managed if you do it properly, if you put review windows, if you put specific timelines and time frames, by which you allow people to review and decide what's happening. And also, issues have also, or can also, challenges can also arise when you arrive at an exploitation outcome, and then the discussion goes around how do you share the outcomes of that? How do you share the sort of the royalties out of this? Because if it's not properly understood who put what into it and how that specifically led to the exploitation outcome, then there is an issue. So again, I invite you to have a look at this and see how these relate with your, if they relate with your work and how they do. So, and in order to manage that, in order to be able to transact with IP, move it around collaboratively and sort of license it and so, et cetera, you need a framework, you need a licensing framework. Again, it's sort of a very simple concept, but it doesn't necessarily come through when you're working in a project or when you are putting together a proposal. My experience and my suggestion is if you do work in an upcoming proposal, I don't know, for September and so on, always add that provision that you will look at how you're going to transact with, based on the results by using a particular kind of a licensed framework. And that's because exploitation is effectively, whichever way you look at it, especially under commercialization, is a lawful use. So you are allowed to make or use or sell or effectively transact that intellectual property. So you have to have some granted rights. And those granted rights, the only way to acquire them or pass them on is through a licensing framework. So an agreement that effectively is a transaction mechanism. You do that every time you buy software, you get a end user license, and also so on. As SMEs, as partners, you know that because every time you enter, you buy something, you procure something, you use something, you have to sign up to a particular license. So from the perspective of intellectual property, that being an asset in itself, intangible, still asset, it's the same thing. You need a license, you need a framework that defines rights and then enables those rights to transact and move from one entity to another. And it's if anything, it sort of reduces disputes. If anything, if you want to see what the clear benefit is, it reduces disputes and sort of speeds up the deal and the movement between the various partners. So what we've done in Convert to Green and other projects is we put a set of licensing frameworks and transactional sort of discussions in there. I'm not going to go through the whole thing again. That's sort of something for a different discussion. But clearly, from experience, what we've always found the issue with is the concept of improvement, meaning when you get intellectual property into your project, that potentially can come from different vectors, different partners. What happens when something new is generated, okay? And how does that new innovation, intellectual property and so on, how does it connect to existing background IP? And that is it an improvement? Has it been is it the result of a modification or enhancement and so on of a party's particular IP? Now, again, that's on principle and on paper sounds very simple. Of course, I brought my idea. That idea generated, a follow-up. Therefore, I have certain rights to that follow-up. But as I'm sure you know, this is not necessarily the case every time. There is always a very complicated arrangement as to, what happens, who owns it, why, etc., 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 which is even more complicated when you have joint results. So this again is an area that you need to pay, and we pay special attention when we're looking at projects. Now, the overall, if you look at the sort of the legal framework of EU projects, you have the DESCA, you have the consortium agreements, etc., etc. They follow a very kind of a set path of who owns and what you need to do and so on. However, again, as I was saying earlier, typically issues and challenges arise at the point of use. When you take that IP, when you take those provisions and you translate them into an open call, into a side project or into an engagement between internal and external partners, that's typically where that sort of a common language and standard terms tend to drop and will need specific modifications and sort of a new language. For example, again, exploitation access. Who gets to use it exclusively, non-exclusively? Would you do it, would you use it with any royalties? Where in the field? What territory? What applications, etc., etc. And these are the things that we've had quite a few discussions in the past. And like I said, this particular sort of presentation was partly initiated by discussions that we've had with partners and with external clients, partners, and so on in open calls, where we had to step in and sort of generate and create that common platform, common language, so partners and externals can communicate based on the same language, rather than each one having their own understanding of intellectual property and how it fits in a collaborative project, more specifically how it fits in an open call. So these are the things that we sort of always take into account. And again, some takeaways, and we come close to the end of this part, is always align and document earlier. Make sure you know what your background is, you know what you're getting into, and you have a publication review and so on. And always in the context of a project, make intellectual property serve exploitation. Always look at what is the exploitation intentions of the project, and then you make IP fit into that picture. You cannot do it the other way around. It's not the way to go, and it causes more problems than sort of solving them. So let's assume now that we've had everything done. We have intellectual property. We're into a commercial into a research project, and we came up with something, and we're thinking, okay, how do we then take full advantage of that? We have full ownership. The partners are happy to negotiate with us to take a license, etc., etc., etc. So all the circumstances and all the drivers and all the vectors are in place to enable you to move on towards the next step, and which is the commercialization of your ideas. Again, subset of exploitation. So the point now is how to de-risk that process and how to make sure that you go through a certain sort of steps that are common for pretty much everyone, making sure that you align all the decisions, you know where you are, you know where you go next, and you know where you insert your intellectual property at that stage. And typically what I've used, still use actually, is sort of this kind of a matrix. It's actually a little bit more kind of three-dimensional because there's a lot sort of depth in the background that when you look at the concept analysis, you have to sort of do a whole set of things and arrive at a certain sort of stages and steps before you can validate it and so on. So I'm just very briefly going to go through it, and then again, I'll allow you to review it when you get a chance. The point is that you go through a certain set of steps, just like your innovation journey, just like every other sort of research project or sort of a technical project. And you, at each point, you have to arrive at a particular outcome before you're allowed to go to the next. So you have to go through your concept analysis, make sure that everything checks out, you have your IP, you have your key checkpoints and so on. And that gives you sort of a goal to proceed to the feasibility study and so on and so forth. So by sort of going through it, or at least, again, we'll have to explore that sort of a framework at a different sort of a webinar, but you can sort of choose which areas to focus on. If your project is primarily around technical development, then you have to sort of focus around the analysis of the concept. Does it work? Can it fit into a market and so on? Can you engineer it? Can you have a pre-production? So you sort of you go through vertically through this matrix and arrive at a particular decision. When you start on that, now pretty much as soon as you have a testable idea or any potential IPO results, so you come out of the project, there are some results, you can then sort of put them through a matrix and start looking and say, okay, I can see what needs to be done next. And again, indeed, this is interesting if you look at it from a project perspective, because you can sort of, if you like, guide the project proposal through that phase. And you say, well, we aim to arrive at that point at the particular sort of time and so on. And what triggers that is when you have an early stage, I should say, idea. If it's an invention, if it's, if you're forming a project consortium, if you're preparing a grant or a funding round and so on, that's when you start thinking, okay, where am I on that sort of a matrix, which is sort of a two-dimensional here, but it's three-dimensional in terms of acts and steps. And how do you use it? You sort of map the process, you set the owners who do what, and then you go through this sort of evidence-based gates, and then you write the criteria, and then you have a very clearly written process that allows you to make a sort of informed decisions. And at the same time, you embed IP and licensing checkpoints. At every point when you're building your technical sort of a prototype, you have to look at sort of what is your, what are the technical effects? Are they novel? Are they, should we consider protecting them and so on? If you're in collaboration while you're doing this in the project, then you have to add your background list. You have to add your publication review and so on, just to enhance that framework and help you to make sure that you don't lose any opportunities. A few more slides and we're finished. And takeaway, I did say early on that this is not a one-size-fits-all. And I meant that, but you cannot make the same decision for different sort of partners and different people and so on. But you can use the process and the structure that sort of allows you to evaluate what you have or you don't have, and then sort of make additional provisions for that. Key takeaway for me: IP has to be always built in, not sort of bolted on. It's not an afterthought. It has to be built into the process of innovating in your innovation journey. So again, that needs to be stressed and emphasized through this. And you always have the choice to choose the path to value. and how you're going to get there. So, and you know, to do it deliberately and keep improving it by constantly refining the process. Right, wrapping up. What we covered today very quickly, I think, in sort of at the top level is a few things about IP foundations, what counts as IP and why it's a strategic asset. Looked at the background, sort of, I should say, looked at collaborative IP as a whole and how and where the challenges arise and what you should be paying attention. A brief sort of a look at the licensing framework, and then a very brief look through a commercialization process, how you get, you know, kind of a stage-gated path from, you know, an idea to your prototype, concept, etc., etc. The key takeaways: always plan early. If you collaborate, you need to have clarity as to ownership, access, and publication rules before you start. Consider that licensing makes use possible. It sort of, you know, it makes your IP into transferable rights that you can use to transact and get commercial traction and benefit. And ultimately, at the end, you always have to revisit all these assumptions at a milestone and at its sort of a point, rather than just setting it in stone and saying that's it, fine. Next steps. Additional webinars are being planned, and we can sort of dive deeper into the subject. We can talk about IP protection strategies and protection pathways for software, for hardware, and so on. Hardware being my particular sort of a preference, and through that we look at sort of how we can look at how you perform a prior art search, and why you want to do that, and what stage, and how you build the IP landscape and your freedom to operate. We touched these very superficially because I think they merit their own discussion. Otherwise, we wouldn't be able to do them justice today. I'm also interested in sort of having a licensing webinar to discuss key terms, provisions, and how to construct a license that fits into sort of the context of an EU project, a proposal, and down the stream when you get to the stage where you and your partners want to exploit intellectual property. And generally speaking, go through the commercialization process that I explained, you know, sort of that two-dimensional. I want to make it three-dimensional so we can explore what sort of what's sitting behind it. And as always, and my thanks to John for arranging this, but, you know, as always, if you have any questions about innovation, or if you want just any sanity check, just get in touch. Just drop me an email, connect on LinkedIn, we'll have a chat and see what happens. Thank you so much for your attention.